All right. Hello, everyone. My name is Data Wilson, CEO and founder of CHIP, and welcome to another edition of the Represented Series, Education Edition. And I'm really excited to bring on our next guest, which is Chioma Deere. Chioma Deere is the managing attorney and owner of the Deere Law Firm in West Palm Beach, Florida, which provides thoughtful and thorough legal services with a focus on wills, trusts, estate planning, probate, and trust administration using the power of technology. Chioma Deere is known by her colleagues as a technology lawyer who frequently teaches her fellow lawyers and judges about data and law. Chioma has served in various capacities to support her community, including on the Florida Bar and local volunteer legal and civic organizations. She is a proud member of the American Academy of Estate Planning Attorneys, the Association of Black Estate Planning Professionals, and she is an amazing board member for our company, CHIP. Chioma is dedicated to educating clients and the community with monthly community webinars and speaking engagements about estate planning and probate in the digital age. So without further ado, I'm extremely excited to bring on Chioma. Hello, welcome.
Hi, Dana. Thank you so much for having me on.
No, absolutely. It's always a pleasure. I'm glad to have you back now for Education Edition. And I know everyone is really excited to hear everything that you're going to talk about today. So I am going to disappear and leave it up to you.
Great. Thank you so much for the opportunity to share today. And my topic is, I guess, provocative, right? Because we do want to get into what is estate planning, all about wills and so on. And what I preach about all day long is where there's no will, there's a way, but you may not like it. As Dana indicated, this is actually my contact information. Just to give you a little bit more about myself and also to manage your expectations today. I am a Florida licensed attorney, which means I am not licensed in the entire 50 states. Selecting an attorney, especially an estate planning attorney, is an important decision. And of course, you want to find an attorney who's licensed in the area and the state that you need help in. The information that I'll provide today will be general in nature, and I will give you some specifics about how us Florida attorneys handle certain things. I graduated from Pace Law School over 14 years ago. I've been a Florida bar attorney my entire career. I have a background in litigation. I've tried cases and things like that. And I'm also a certified technology lawyer. I'm certified e-discovery specialist. And I am proud to be a community educator and presenter. So I want to launch into really the key question that we want to ask, that I want to ask, and that I've heard people talk about over and over again when it comes to estate planning, is whether or not someone had to deal with not just the grief and pain of someone passing away, but also the life, the legacy, the stuff, the finances, burdens maybe, that they leave behind. And one of the things that I'm going to go over with you, or some of the things that we're going to discuss today, is, how to talk about, how to deal with, and how to be empowered in knowledge about what to do. And we'll talk about estate planning and wills and trust as well. So what we're going to talk about today is what happens if there's no will. A big thing that is, common everywhere is the probate process. So we'll talk about that as well. I'll talk about what a will is, why you need a will, why everyone needs a will, and how a will helps. We'll go into estate planning, which is broader than wills and probate, and talk about some of the things in there, including what's a trust, how can estate planning help build generational wealth, and how can estate planning protect you and protect your family while you're alive, as well as all important thing is how can estate planning avoid probate. So here's my no will scenario, and we'll just pick a family, right? The husband and wife are older, and they decided that they're going to put a will together. They're going to decide who's going to get whatever they have left, but they're not going to put a will together. And what that really means, it boils down to is whether or not those younger children, that younger generation is going to get anything. It is also about, where is that money being spent? That those dollar bills, the $100 bills that were being counted, where is that money going? Who is it going to? Because you'd be surprised with a will that often it's not going to the loved ones that you thought you wanted to leave stuff for. And then finally, we're dealing with probate court. You may or may not have to do that, but very often, if you have any type of significant assets, you are dealing with probate court. So I wanted to make sure that we were aware of that and helped you to talk about some of those scenarios. And this is just one of many, but I'm sure as we talk about it, you can think of some other places, some other scenarios where your family might fit in. So if you die without a will, you have to go through the probate process, okay? And a lot of people let me go back to that. If you die without a will, what's very important, it's the process called intestate. Now, some states and counties have easier processes than others. You will have to go through this process wherever in the world your assets are. So if you live in Florida, but you have a piece of land in Vermont, you're going to have to deal with probate in Florida as well as in Vermont. So this infographic I got from thebalance.com. A lot of people are confused about this probate process and why it's even needed. Now, in Florida and in many other states, a will controls all of the assets that you own at the time of death, that you personally own at the time of your death. And I say that because if a trust owns it, then the will doesn't control it, and neither does probate. So basically, probate's main purpose is to change the title of the property that you own. Because if you pass away and your family wants to spend or sell or refinance or lease the asset that's in your name, they can't do that until the title on the asset or the account has been changed into their name. And when you think about it, if you want to change title on an asset now, you usually have to sign a document to transfer a title. But if you're not around, you can't sign that document, right? So you have to go to court. And that's the main reason for probate. There are other things that happen in probate, as you can tell from this infographic, which is, identifying the last will, if there is one, and the court will appoint an executor, an administrator, or a personal representative. They'll also identify creditors that you may leave behind. And they also determine the date of death values, which is when an inventory is created. The full inventory of assets that's owned by decedent or a dead person is completed, and appraisal of all the assets are made. And then there's a distribution of those assets. So probate takes care of a lot of things in terms of making sure that everything is accounted for. But things slip through the cracks. I've seen people that take a long, long time to bring an estate to probate. And in the meantime, valuable assets of that family that should have been passed on properly to the next generation or even to the grandchildren are lost forever. Not only that, but, legacy, right? Stories, how this family may have come about, how that grandmother and grandfather may have put this family together may also have been lost during this whole process. So this is what happens during a probate process. The other important thing that I want to go into is that there are in probate what's called non-probate assets as well as probate assets. And another colleague, estate planning attorney of mine, put this together. Non-probate assets are easy, right? Because we're not talking about probate. We're talking about things that have beneficiaries, things that have joint owners, things that are owned by a trust. And in all of these instances, if you look at each one of them, the asset does not have to go to probate. So they go under, yes, it goes to each of those different people. But when you're dealing with a probate asset, especially if there's no will, What's key here is that your next of kin will inherit, which means somebody that you may not want to get your stuff after you pass away will end up getting your stuff. Not only that, you may not have any control over what happens to your estate and whether or not there are anything else that could be added to your estate. None of that is passed on. None of that is communicated to your family and all the responsible people. The court gets to choose who will be responsible for your estate, not you. So when you think about it, not having a will really takes all of your assets, all of your life hard-earned fruits of your labor. They're all kind of floating out there. And yes, you can leave it as such. You can plan to die intestate. But what I find is that when you're doing that, you're leaving everything up to chance and everything up to fate. And if you plan on leaving anything or want to leave anything to your children or any other family member, a loved one, there's no guarantee that they will see anything that you plan to leave for them. And that is where not having a will, you can still have probate, but you may not like the outcome of this whole thing. So why have a will? Well, first, let's talk about what a will is. It's a written direction controlling the transferring of property at death and the guardians for minor children. That's really important. The laws of each state set the formal requirement for a legally valid will. Now, while everyone, remembers or sees or thinks about a will as, everyone sitting around a long table, or, coming to some family room and having it being read, it's usually not like that. Usually what happens is the person who is the personal representative or the executor will start the process of probate with that will if there are probatable assets. And that's pretty important. One thing that's really important is you must go to court to probate a will. If you know that something needs to be addressed, title needs to be transferred from the asset of the dead person to the beneficiaries or to their heirs, then you have to go to court, right? It's often required. Now, some wills actually create trusts, and those are called testamentary trusts. And on the other hand, wills usually go hand in hand with trusts. In fact, there's in Florida what's called a pour over will, which basically means once you pass away, whatever the trust doesn't own, your will ask the court to make sure that those assets get transferred into your trust. Or if the trust can't be found or anything like that, that everything that's in your trust should be followed as though it were your will. And that's pretty important as well. So you decide in a will who gets your property instead of the law making the choice for you. You get to name a guardian for your minor children. You also get to say who you do not want to be your guardian of your minor children. That can be included as well. You also decide who bears any tax burden of anything that's been transferred. Your estate can bear it, or the beneficiaries can bear it yourself. And then the will decides what happens to all your assets, whether or not it's in a trust. But even a trust needs a will, okay? So the other thing that I wanted to talk about as well is whether or not someone had to administer a will, right? Now, that is often something that a lot of people don't think about. Oh, yeah, I want a will, but are you picking the right people to administer your will? Are you picking the right executors? Are you picking more than one executor? Do you have backups in your will as to who is going to be the next in line should something happen to this person? Now, one of the things that I always stress is that you want to pick someone when you're talking about who's going to be your executor or who's going to be an administrator or who's going to be a personal representative, that there's someone that you can trust, who's trustworthy, who's reliable, and who can understand and read financial and legal documents. The financial and legal documents are important, right? Because you want someone who will know what to do with an IRA versus a pension versus a 401k versus a regular savings account versus a brokerage account. You want someone who would be able to read and or hire someone to help them if they needed to read a contract, a operating agreement, a partnership agreement, licensing agreement, things like that, that someone may be leaving behind, which is included in their will. Traditionally, when we're talking about a will, we're really talking about estate planning, right? And estate planning is much broader than just simply drafting a will. Estate planning traditionally consists of wills and trusts, but it focuses on the accumulation, the preservation, and the distribution of not only your financial assets and worldly possessions, but also it protects material wealth from probate and minimizes taxes. One of the things that's really important about probate, and that I may have glossed over, is it's really expensive and it's time consuming. So depending on what's left behind, sometimes probate can actually eat that up. If you're going to court, especially here in Florida, and you have a will and there's more than one beneficiaries, you are required to have an attorney. An attorney is going to charge you either hourly or based on the value of the estate and all the work that has to be done to transfer all of those assets, right? So estate planning, when it comes to probate, avoiding probate is really a big deal. And then, of course, minimizing taxes. So why a trust, right? The first thing is it avoids probate usually. It provides for easy transfers, right? And a revocable trust is a trust agreement created by you to manage your assets during your lifetime and distribute the remaining assets after your death. And one of the things that's really important is distributing the assets after your death. Because the trust really is something that actually ends up owning those assets while you're alive. When you pass away, you don't have to ask the court to change it out of your name, the dead person's name, into the trust, because the trust already owns it. So you don't need to ask permission to change the assets title. The other important things about trust is that they preserve your estate for children in the event of being remarried. So think about it. A married couple comes together, somebody passes away, the remaining spouse gets everything from that spouse, right? Because usually spouses are first in line. But then that spouse remarries and gets a new spouse. If that spouse then passes away, then what's left is the new spouse with all the assets of the first spouse, and everything skips a generation, or it skips that initial married couple's family and goes to the new spouse's family. That happens all the time. Several of the people that I know, they've dealt with that, and that's one of the reasons they want to set up a trust that will protect the assets from getting sucked into the second marriage. Trust can be revocable up until your deathbed, so most times. And then there are living protections that trust can provide, right? They also allow you to protect you, to make sure that you are protected while you're alive should you become disabled or incapacitated. Now, one of the things that I always talk about is the fact that we all live digital lives. And with digital lives come digital assets. Now, one of the things that I talk about with my clients all the time is, how are you accounting for your digital assets? The ones that are not tangible, the ones that have value, how will you pass them on? Can they even be passed on? Is the way that you hold them something that will allow your family or your loved ones to gain access to them? This is a big part of my estate planning. And I always try to keep that in mind whenever I'm talking to anyone who has any type of social media presence, a business, images, if they're an artist, or if they just like to dibble and dabble in NFTs and cryptocurrencies, we still want to account for all of these in estate plans. And then I also wanted to touch lightly on a holistic view of wealth and legacy, because a lot of what we're talking about here is creating or building and sustaining intergenerational and generational wealth. A lot, what I've heard from other CHIP members is after the second generation, that wealth decreases almost exponentially. And this holistic view of wealth and legacy will allow people to keep things in mind, but also keep a conversation flowing throughout their family that focuses on core values, wisdom, community, as well as the financial assets that they may have and are willing to pass on. Think about all of the businesses that have been created in the pandemic, during the pandemic. One of the things that's really important is if you are accumulating this type of wealth, or if you're creating this type of legacy by having a business, then how are you leaving it behind? Or how are you taking care of it? If you're a licensee, how are you acknowledging that and keeping that as a part of your estate plan? All of that is really important. So, although we went over a lot, and I could talk for hours, and I do talk for an hour and a half for my webinars. One of the things that I wanted to just wrap up with is exactly what you need to think about to start your estate planning, right? Get an assessment of what your needs are from an experienced estate planning attorney, and start now. One of the things that you can do is just do a consultation. I mean, there are a lot of people out there that will allow you to do that. It may be paid, it may be free, but even so, or attend a webinar, get more information about this. And I know if you have a financial advisor or a CPA, they are telling you to look into estate planning, and you should. So when you do talk to an estate planning attorney, really think about the references, not just the Google reviews, if you can. Most estate planning attorneys deal in flat fees. I don't recommend hourly fees unless it's a complicated estate plan and they explain that exactly why they would be doing an hourly fee for you. And then if they're creating a trust for you, they need to be able to help you to fund that trust, right? To make sure that the trust owns the stuff and not just give you documents and tell you good luck. And then think about legacy planning, right? Think big, dream big for your family and your loved ones, and exactly talk about how you can memorialize as well as create legacy planning for you and your family. They should be giving you instructions and guidance on an ongoing basis. Avoid just going online to find documents and filling them out yourself. It could actually wreak havoc for your family if they aren't done properly, and you won't avoid probate at all. As in terms of what you should do for estate planning, even without a will or a trust, at a minimum, this is what you should be considered as critical needs for taking care of yourself and your loved ones, not only while you're alive, but also after you've passed away. A living or revocable trust. More than that, if your estate planning attorney recommends more in terms of planning, or at least, at the very minimum, a last will and testament. You should have a living will, which talks about what you want to have happen while you're in the act of dying. How do you want to maintain the dignity of your life, even in your final moments? And then make sure that you have a power of attorney, a healthcare surrogate, or what is called a healthcare power of attorney, a pre-need guardian. While you're an adult, you may need a guardian or a conservator. You can actually pick who you want to do this before you get to that point in life, or if you ever do. And then if you don't have a trust that owns everything or is a beneficiary of everything, then make sure that you have beneficiary designations on all of your accounts. One of the things that I find happens all the time when we talk about what kind of no will scenario could happen is people think, well, why don't I just leave everything to this one person and they will divvy it out the way they know I want to divvy it out to them. Now, I can't even begin to tell you how disastrous that could be. Just some things to ponder if you are thinking about going this route. If it is a child and it's not an only child and they're married and they predecease you, then what? What about the fact that their person, their spouse may influence them to do something other than what you planned? Also, what will happen if other people in the family pass away? How will you ensure that things will go according to plan? I find that I get that a lot. My sister is responsible. She should get all of the money. She should get all of the assets, and she will divvy it up because they want to pass that decision on to someone else. Please don't do that to your family. Please protect your legacy and your wealth by making sure things are written down just like you want them to. Estate planning can bring you peace of mind and help you sleep better, but also knowing that everything is in place, it will help you to make sure that you have everything that you need while you're alive to take care of you. I can't imagine what would happen if things go awry and all the wealth and things you've built up, the assets you've built up, just fall off a cliff because you get sick. That's one way that estate planning can help you with what you're doing. So that's my time. Thank you very much for allowing me on, Dana. Here's my contact information. And I really appreciate the time and allowing me to walk through this process with you. Estate planning for me is really important, not just about while you are, after you've passed on, but also while you are alive. It's really important that you take care of yourself because you're the money maker, right? You're the breadwinner and your legacy is important. And I hope that you will share this information with your family members because there's a lot that a lot of people don't know about estate planning, and knowledge will empower you and empower your family to take care of this important responsibility while you're alive.
Oh, there we go. Thank you so much, Chioma. That was absolutely amazing and brilliant. And I know this is such an important topic and something that we don't talk about often enough. Definitely not the most comfortable topic to always discuss is estate planning and wills and trusts, but obviously the most important, right? It's like we build up all of this wealth and we have all of these assets. And even if you're still building or just getting started, right, you should still have that conversation. So I'm glad that you kind of brought a lot of that to the forefront, especially in this digital age that we're all in. And that's the one thing we probably forget the most about, right, is our digital footprint and how we're protecting that. So thank you again. Always appreciate having you on the Represented series, and I'm sure we'll have you back again. Everyone, take care, stay safe, and please continue to catch up and watch other episodes. Have a wonderful day.
Thanks for having me, Dana.
Absolutely.